Well, hello there, and welcome to Ask a Lawyer here on CP24. My name, John Scholes. Shortly on your screen, employment lawyer and my pal, Lior Samfiru, always here every week to fill your knowledge and educate you with employment laws and workplace rights. That's what we focus on the show every week. Really important stuff. We all work. We all need to know this information. Reach out to Lior anytime, by the way. The phone number, 1-855-821-5900. Ask at EmploymentLawyer.ca, and we'll give you some other contact info throughout the show. Always have a main topic. You'll know that if you've watched this before. And this week it's going to be Trump tariffs, 3 key rights for non-union workers. So we'll get to that. Talk about top of mind. That's coming up in just a bit. Some phone calls from one of our radio shows as well. And Lior, it's time for you, pal. We always start off with the week that was, or case of the day, to get us warmed up. What do you got for us this week?
Hey, John, great to be here, to cover this important topic, to educate everyone, and to hopefully alleviate some concerns that people may have about workplace rights. We're going to talk later on the show about the impact of tariffs on your job, what you can do if your job has been impacted. I know this is top of mind. I know you have concerns about what happens if your job is impacted, if you lose it, if you're put on a temporary layoff. We're going to cover that because guess what? You have rights. Our rights don't go anywhere just because we may be dealing with some problems south of the border. Your rights are still here, whether it's mistreatment by your boss, whether you lost your job, whether you've been forced to resign, et cetera, et cetera, et cetera. Some of the best laws right here in this province right now are there for you. And every single day, I speak with people that want to know their rights. They want to understand it, need some help resolving those workplace problems. So if that's you, a great place to start is this 30 minutes right now to understand those rights. But of course, just 30 minutes. We can't cover every topic. If you need some help with your specific situation, you can reach me in the office by phone or email anytime. We'll give you that number throughout the show. Now that we know that, let's start talking about a case that I dealt with just over the past few days. I spoke with a gentleman that has worked in a warehouse for about 3 years. So within the warehouse, he was driving, picking up orders from one area to the other, driving a big piece of equipment. Recently, for some health reasons, he felt, and his doctor agreed, that he could no longer drive safely. He could do other work, but he could no longer drive safely. He talked to his boss, and boss said, well, get us a note from your doctor, which is exactly the right thing to do. So he did. He got a note from a doctor saying that for medical reasons, he cannot drive. He needs to be provided other duties that do not involve driving. Well, the employer looked at the letter and said, well, this doesn't give us any information. This doesn't tell us what your condition is. How do we know if this is legitimate? How can we assess if this is right? So unless you give us something more detailed, we're not going to accommodate you. This person then called me. Their big concern, of course, was, I don't want to disclose my private medical condition. So what do I do here? It was exactly the right call for him to make and the right question to ask. Here's why. His employer, your employer, doesn't have a right to know the private medical condition that you have. That is your personal data. That's your personal information. It's none of the employer's business. Here's the thing. The employer doesn't get to decide if the doctor is right, to evaluate what the doctor says, to corroborate it. Your employer must do what the doctor says. It's as simple as that. So you should tell your employer that you have a medical condition that prevents you from doing certain work. But what that condition is, how long you've had it, or what treatment you're getting, that is offside. It's not relevant. It doesn't matter. So in this case, by his employer saying, this doctor's note is not good enough, we need to know all the particulars of your condition, this employer is doing something wrong. By not accommodating, that's a human rights violation. That could also be a constructive dismissal. It's illegal. That doctor's note doesn't need to provide all the details. An employer has an obligation to accommodate, whether it's modified duties or modified hours or working from home. And an employer that doesn't do that is going to be absolutely on the wrong side of the law.
Lior, quickly, what can an employer ask if not, what's wrong with you, what medication you need, that sort of thing? What can they ask?
So they can ask, can you and can you not work? What are your limitations? How long are you going to have those limitations? When can you expect to come back to work? When are you going to have an update for us? All those are legitimate questions. I'm going to say even necessary questions. But to go beyond that and say, tell us what your condition is, whether it's a physical or a mental health type of a condition, those are offside, inappropriate. We have a right to privacy, and that means that personal medical condition is no one else's business.
The website, EmploymentLawyer.ca, that is where you want to go to find a radio show close to you in your community to catch us weekly on the air. Lior, let's get to our first phone call from the radio show and talk about it. Here it comes.
I spent just over a year in a specialized technical role at a small business. After a minor mistake, they let me go. No paperwork, no explanation. They said they'd send a small payout within days, but it's been 3 weeks and I haven't received anything.
Okay.
John, if I had a dollar for every time someone calls me with that type of a situation, man, we'd be talking a lot of money here, because this is a very common scenario. Number one is employer believing that, well, just because someone made a mistake, we can let them go. We don't really have to pay them much of anything, number one. Number two, employers thinking that, well, you only worked for a year. We probably don't owe you anything or very little. Both those things are wrong. Number one, unless she did something terrible, she's entitled to her full severance even if she made a mistake. Number two is just because she's been there for a short period of time, a year, doesn't mean her severance is minimal. She has significant severance entitlement. Same with you at home. Even as a short service employee, severance is significant. So we're going to see how much severance she's actually owed. We're going to use the severance calculator tool. Of course, you can find that at pocketemploymentlawyer.ca. We're going to use it right now so you can see how much this person is owed. So she's been there for a year in a technical role. She's 48 years of age. Her employer has not paid her any severance because it's wrong. Why is it wrong? We see right there she's owed 3 to 5 months of severance. Okay, 3 to 5 months, even though she's been there for a year or so, and she's not necessarily in a very senior role. That's why you use the severance calculator. Check it out for yourself, pocketemploymentlawyer.ca.
Okay, Leo, let's grab a quick break. On the other side, as always, we'll dive into our main topic, and that will be Trump tariffs. 3 key things you need to know for non-unionized workers. That's on the other side, so stay with us. Lots more Ask a Lawyer is coming right up.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
Okay, welcome back to Ask a Lawyer on CP24. Reach out to Lior Samfiru anytime, EmploymentLawyer.ca. There's your phone number, 1-855-821-5900. Email, followed up, add it to it, ask@EmploymentLawyer.ca. And you can always scan that QR code as well. There, Lior, want to get into our main topic, a really important one this week. They're always important, every week, but this one especially, it's top of mind, as they say. Trump tariffs, 3 key rights for non-unionized workers. Number one, Lior, you can't be temporarily laid off without agreement, correct?
So if these tariffs do start impacting our economy, I think one of the first things you will see is employers putting employees on a temporary layoff. It happened during the pandemic, and it may happen now if the economy gets impacted. So you may see a lot of that. And it may be easy to think that, well, if everyone is put on a temporary layoff, it must be legal. Well, guess what? It's not. For most employees, the vast majority, being put on a temporary layoff is not legal. It's a constructive dismissal, something the employer is not allowed to do. You can choose to consider that temporary layoff as a termination, as a constructive dismissal, and get your full severance and move on somewhere else. It's something that is a right that you have, and that right doesn't get impacted because the economy is bad, because your employer's business is impacted by tariffs. Your rights, those rights are still there, so you do not have to accept a temporary layoff.
Second thing you need to know, Lior, is this: significant unwanted changes cannot be made to your job.
So other things we may see if jobs or economy is being impacted by tariffs is maybe we'll reduce your pay, we'll change your hours, we'll go cut you to part-time. Wait a second, let's not go so fast, because for most people, those changes are also not legal. Your employer does not have a right to make significant changes to the terms of your employment, to your pay, to your hours, to your position. Again, if they do, that's a constructive dismissal, even if they're not doing it because they're bad. Even if they're doing it for legitimate business reasons, it's still the case that they don't have a right to do that. So if you're faced with a significant change, you have two options. Of course, you can accept that change and continue working, but you have the second option, which is to consider that as a termination and then get your severance and move on. Of course, if you accept the change, you've given the company now the right to do it again and again, which is a huge problem. So many people may in fact choose to say, no, that's not okay. That's a constructive dismissal. Give me my severance, and let's be done with it.
This third key right, Lior, we're going to get to now to wrap up the segment, or at least wrap up this topic for this week. It may surprise a lot of people, but you can be let go, but you got to get severance, right?
So we don't know yet how economy is going to be impacted, how the workforce is going to be impacted. But here's what I can tell you. Your employer is allowed to let you go. You may say, well, you don't really have a good reason, you haven't been impacted. Regardless, your employer does have a right to let you go. But, and this is the big one, they have to pay you your severance. Now, you cannot be let go for a discriminatory reason, of course. You cannot be let go because of your age or ethnicity, etc. But other than that, your employer is allowed to let you go. Severance has to be paid, and that severance can be as much as 24 months pay. As you've heard me say before, 90% of the people, and it's probably more than 90%, but let's go with 90%, when they're let go, are offered or paid a lot less than what they're owed. So chances are the same will happen to you, especially if the business may be struggling. They may think that they'll get a break on severance. No, there's no break on severance. Even if the business is struggling, full severance must be paid.
Well, as we mentioned earlier, EmploymentLawyer.ca is where you want to go to catch one of our radio shows in a market close to you. We'll get to our second phone call for this show, Lior, right now. Have a listen.
I've been a contractor with the same company for years, same hours, same boss, regular performance reviews, but after a bad review, I'm worried they're going to cut me. Do I have any rights here?
Well, this person kind of looks like an employee and acts like an employee, so I'm not going to shock anyone by saying, yeah, this person is an employee. They may be called a contractor, but that doesn't matter. They've been misclassified. So if she actually works with the same company, takes instructions from her boss, she's an employee, which means she has the rights of an employee, including the right to get severance. So as I said before, her employer is allowed to let her go, but severance has to be paid up to 24 months pay. And the fact that she may have done something wrong, maybe her performance is not fantastic, doesn't mean that she can be let go without that severance. So yes, she is also, by the way, potentially owed overtime, vacation pay. Very, very common to be misclassified. If you want to know if you're an employer or contractor, again, use the Pocket Employment Lawyer tool. You'll find that at PocketEmploymentLawyer.ca. Use that tool and find out for free.
Okay, Lior, for you as well, we'll take a short break. It'll give us enough time to switch gears and get our good pal James Fireman in here from DisabilityRights.ca. Same firm, other hallway. We got stuff to discuss on the other side of this break. We'll do that as we continue more Ask a Lawyer here on CP24.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
Okay, welcome back to Ask a Lawyer on CP24. Now we got our good pal James Fireman, a partner at DisabilityRights.ca. We've been talking to Lior, of course, same firm across the hallway because there's always interplay between the two. And I want to tell you right off the top how you can reach James as well. The phone number, that'll look familiar to you, 1-855-821-5900. Email now is ask@disabilityrights.ca. And again, scan the QR code. James, we got a phone call. We got questions coming up, but we always start off with just giving us warmed up exactly what you do over there every day. Right?
Hey, John. Well, so I do something very different than what Lior does. Lior and his team is there to discuss any issues related to employment law, your employment situation, anything that comes up. That's what he and his team are dealing with. Now, within that employment relationship, though, you're almost always going to get benefits, which are going to include, in most cases, long-term disability. Now, nobody spends a whole lot of time thinking about their long-term disability policy until they become medically unable to work. And they think, okay, well, I have this LTD policy, so I'm set. Unfortunately, the LTD process is really complicated, and most people find it quite frustrating. And the reason is because there's very little oversight. And so people involved in this process need help. And that is what my team is there for. Whether you are just applying for benefits or whether you've applied and you're having difficulty in the adjudication process, your insurance company is perhaps asking you to do something and you're not sure that you should be doing it. Or if you've applied and your benefits have been denied or they were approved and now have been cut off. That's exactly what my team is there for. Wherever you are in the disability benefits process, give us a call if you need any help whatsoever. And the good news is it's a 100% free consultation.
With that, James, let's get to a phone call. We always have one every week for you, pal. So here it comes. Listen up.
My question is about long-term disability. A lot of companies have short-term, then it can go into long-term. Now, you can have a case agent phone you and say on the phone, you've been accepted, your claim, and then they literally can phone you 2 days later and say, oh, you've been denied. I was wondering, can they do that? And is it true that a doctor can still say you cannot work, but because you're in long-term, they can still turn you down your claim?
This is exactly what I was just talking about. So people who are engaged in this process find it very confusing and find it very frustrating. The insurance company says one thing one day and something completely different the next day. Your doctor tells you that you can't work and your insurance company says, we don't care. And you're thinking, well, wait a minute, I have this long-term disability policy that's supposed to be there for exactly this situation. How come I'm not getting my benefits? And the answer is really because when you're applying for long-term disability benefits, there is virtually no oversight. There is nothing that requires the insurance company to actually abide by what the policy says it's supposed to do, with the lone exception of if they don't, and you go out and you talk to a lawyer and you start litigation, then and only then is the insurance company put in a position where they have to act reasonably. But until you do that, the insurance company can get away with pretty much whatever they want to. So are they able to do that when your doctor is saying, no, you can't go back to work? Well, no. I mean, theoretically, they could challenge that if they had an expert doctor assess you in person and the doctor said that you weren't able to work and there was some reason why a judge might question what your treating doctor was saying. But that is the exception. If your treating doctor is telling you that you're not able to work, then that is a situation that your insurance company has to abide by. And if they're saying that you're able to go back to work, if they're saying that they have a medical consultant that has looked at the file and says you can go back to work, who cares? Because no judge is going to listen to a medical consultant that's never seen you before over the word of your treating doctors and therapists who are telling you that you're not able to work.
I got a question for you here, James. It's an audio question based on real cases and stuff the firm has encountered before. So listen up, and we'll pick it apart.
What are some of the warning signs that a long-term disability claim might be cut off or denied?
There's a few things that you really want to look out for. Number one, if your insurance company is spending any money more than they absolutely need to, even a dime. Insurance companies don't like to spend money. So if they are sending you for an assessment, if they are saying that they are going to pay for a particular kind of treatment, often called work hardening, if they have hired an investigator and you notice that there's somebody following you around for surveillance, don't worry, that's a rarity, but if you do notice it, those are all pretty good signs that your insurance company is gearing up to try and cut you off. Another thing that you should be aware of is what's called the change of definition date. So once you are approved for benefits, if you're approved for benefits, after you've been receiving them for 2 years, the definition that the insurance company uses to determine whether or not you're entitled changes from whether you are disabled from your own occupation to whether you're disabled from any occupation. And so before you hit that 2-year mark, it is pretty common for insurance companies to take some of those steps I was just talking about in order to see if they can generate anything that will help justify cutting off your claim.
James, appreciate it, pal. We're going to get Lior back in here momentarily. First, we got to get into a break, so stick around for that. We'll bounce right back with more Ask a Lawyer here on CP24.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
right, welcome back to Ask a Lawyer on CP24. The contact information, again, to reach Lior and his team. Phone number 1-855-821-5900. Ask at EmploymentLawyer.ca for email, and the QR code on the right side of your screen as well. Wrapping up this week again, Lior, with a phone call from one of our radio shows. Listen up, here it comes.
Worked for a company for 33 years. A new company came in and took over the old employer. They made us sign a one-year contract for the same job in the same position. If they decide to let us all go at the end of the contract, do they pay me for 1 year or do they pay me for 33 years? I'm 56 years old.
How about it, Lior? What do you think?
That's hugely problematic, John, because I'd have to see the contract, but it's quite possible that this person is owed nothing if they signed a contract saying you're going to work for a year and then we can let you go and pay you nothing. And the reason why that's problematic is if they hadn't signed this, if they didn't accept this one-year contract, he easily could have been owed 2 years' pay after that 33 years of service. In a sale of a business, you don't want to agree to terms with a new buyer, with a new company that limits your entitlements. Don't sign anything with that buyer without having me review this. For this person, potentially he walked away from 2 years of severance. Be smart. Anytime there's a sale of a business, if you're offered a job, let's have a discussion. Let's make sure you don't walk away from your rights.
And that is the way we're going to end it off for this week, Lior. Thank you so much, and thank you for tuning in. I'll give you the information one more time as we head out the door to reach Lior and his team. It's simple. Phone number 1-855-821-5900. Back it up with that email, ask at EmploymentLawyer.ca. That website, if you want to go to find and use the severance calculator, free and anonymous, it's called PocketEmploymentLawyer.ca. Any other information, cp24.com/askalawyer. And you're all set. Thank you for tuning in. We'll catch you next week.